participants about the nuances and intricacies of the space sector and its connected spheres, specifically in reference to India. We believe that the significance of outer space and its laws and its nexus with human existence is pivotal to comprehend and deliberate and bring about scientific temperament among the people. At the outset, we have distinguished dignitaries present. I now welcome Professor Dr. Suresh V. Nadagowda, sir, Principal and Chairman, University Law College, Bangalore University. I kindly request, sir, to welcome the gathering.
Thank you, Niharika. Good evening to everyone. We have respected panelists, Sri Sandeepa Bhatt, Professor from the Kolkata National University of Juridical Sciences, and we have another Professor, Dr. V. Balakrishna Reddy, who is also a registrar of Nalsar University, and our faculty members, and Deepana Gandhi, who is another panelist, and we also have our distinguished alumni, then the chairman and other members of our alumni association, and the students of LLB, LLM, and research scholars in this virtual platform in the evening. So we are really fortunate to have three panelists who are experts in this area. And we have Sri Balakrishna Reddy, who is a well-known academician, who is a conglomeration of both academic excellence and administrative acumen. He has been serving for more than 1 decade as a registrar of Nalsar, and also established himself as an eminent academician in the country. I take this opportunity to extend you a very warm welcome to this panel discussion, sir. Hearty welcome, sir. We have another distinguished academician and a scholar, Sri Sandeepa Bhatt. Though he is working in National University of Juridical Sciences, Kolkata, he is very much from Karnataka. He is our own person who has also made a remarkable achievement in academics. And thank you very much, sir, for accepting our invitation and being with us this evening as a panelist. Thank you. Hearty welcome to this program. We have another dynamic person, Deepana Gandhi, who has also has an expertise in this area. And I thank you very much, Deepana, for accepting the invitation and being with us today. And we have our distinguished colleagues, Professor V. Sudesh. He is a professor, senior professor, former principal and dean. I extend you a very warm welcome, sir.
Thank you, sir.
And we have Professor Dashrath, who is a dean faculty of law, and other faculty members, Professor Satish Gowda, Dr. Satish Gowda, Dr. Jyoti Vishwanath, Dr. Chandrakanti, all are associate professors. And I extend all of them a very warm welcome to this panel discussion. We have our alumni association president as well as other members, distinguished invitees and advocates, and all our students who have joined here. I extend them all a very warm welcome. And in fact, today's topic is of very current relevance, as one of my brothers is also working as a senior scientist in Indian Space Research Organization. He was also telling that the government is is introducing several new policies to liberalize the space this thing. And in the light of this, we are really eager to know more about this from all our expert panelists. And with this, once again, welcome all of you to this program. And indeed, as I told you in the beginning, our Honorable Vice Chancellor was to preside over this program, as he is engaged with another important program regarding implementation of NEP, New Education Policy, in the affiliated colleges of our Bangalore University. He has assured to join in the course of our discussions. And with this, I request Niharika to take forward the program. Thank you very much.
Thank you so much, sir, for welcoming the gathering. It is now our privilege to introduce the esteemed panelists for today. First, we have with us Dr. V. Balakrishna Reddy, sir. Dr. V. Balakrishna Reddy, sir, is Professor of International Law and is also serving as the Registrar at Nalsar University of Law, Hyderabad since 2014. He also heads the Center for Aerospace and Defense Laws and Center for Tribal and Land Rights at Nalsar. He has more than 18 years of teaching experience and research experience. Dr. Reddy sir was awarded the Meritorious State Teachers Award 2017 by the Higher Education Department, Government of Telangana. Dr. Reddy sir is an internationally recognized expert in the field of international law and particularly international air and space law. At present, he holds a prestigious record for the longest serving registrar of Nalsar. Known globally for his contribution to the field of air and space law, Dr. Reddy sir has also presented papers at numerous prestigious national and international forums, including the United Nations. He was instrumental in bringing the coveted Nobel Peace Prize award-winning Institute of International Law to Nalsar. He has also been a member of the drafting committee constituted by Indian Space Research Organization for drafting model space legislation for India and sensitizing program on WTO GATS and globalization of legal profession, opportunities and challenges for Indian legal fraternity. Dr. Reddy sir is also a well-known academician in the field of international law and has served as a visiting faculty in numerous prestigious universities abroad in countries such as Sri Lanka, United States, Paris, Netherlands, among others. Sir is also professionally associated in the capacity of the visiting faculty in several universities in India. As the head of the Center for Tribal and Land Rights, Dr. Reddy sir has acted as a research and project director for many drafting of several policies and legislations for the central government and state government of Telangana and Andhra Pradesh. As a prolific writer, Dr. Reddy sir has contributed extensively to various national and international journals on different facets of international law. It is truly our honor and privilege to host you today with us, sir. Thank you so much for being a part of our event.
Thank you.
Thank you, sir. I now give the floor to Ms. Anaha to introduce the next panelist.
It is an honor for us to introduce the next panelist, Professor Dr. Sandeepa Bhatt, who's working as a professor of law and director of Center for Aviation and Space Laws at NUJS Kolkata. He has the experience of researching on 5 major research projects sponsored by the World Bank, ISRO, the West Bengal Judicial Academy, Ministry of Justice and Ministry of Environment, Forest and Climate Change. He has the distinction of being a member of the American Society of International Law, Baltimore, United States of America, International Academy of Space Law, Moscow, Russia, and the International Institute of Space Law, Paris, France. Dr. Bhatt has published over 3 books on space law and 3 books on medical law. In addition, he has published more than 50 articles in the Journal of International and National Repute. He has presented over 110 research papers in the international and national conferences, including the coveted International Astronautical Congress, as well as in international conferences held in Jakarta, Seoul, Sharjah, Singapore, Paris, Austin, and Southampton. He also has the distinction of being a member of the International Space Research Organization's Expert Advisory Group for drafting the National Space Act for India. It is also a pleasure for me to introduce our next panelist, Ms. Deepana Gandhi, who is the Senior Guidance, Navigation and Controls Engineer working in the India and United Nations Office for Outer Space Affairs, Space Corps Women. We extend a warm and hearty welcome to both our panelists, to all the 3 of our panelists today.
Thank you. Thank you.
Without further ado, we shall begin with the panel discussion. So to begin with, it is with honor to mention that India's space program stands out as one of the most cost-effective in the world. India has earned worldwide recognition for launching lunar probes, building satellites, ferrying foreign satellites up, and has even succeeded in reaching Mars. Indian space program has attracted global attention for its accelerated rate of development, with a critical appreciation for the extraordinary explorations, such as the Mars Orbiter mission, or Mangalyaan, or Chandrayaan-2 mission. So it is truly a very interesting and necessary topic that we are now bringing forth to our audience. And it is our honor to have the panelists to discuss on the same.
To bring about a legal aspect to the liberalization of the space sector, India has enacted its first SATCOM policy in 1997 and later in 2000. The need for regulations that reflect the changing dynamics in the field of space law has led the Indian Space Research Organization to release a draft for a new SATCOM policy in 2020. This policy details that private players will be provided a level playing field in building satellites and other space-based services. Private sector firms are expected to play an important role in future projects around the world and in India. I would like to move on to the introductory remarks by the panelists. If we could begin with the introductory remarks by Professor V. Balakrisna Reddy.
So good evening, everyone. Thank you. So I'll begin with what is the philosophy of Indian space program. Okay. So I'm audible to you? Yeah. So
Yes, sir,
what is the philosophy of Indian space program? Then we'll move into the commercialization, privatization, liberalization, this thing. If you look at, I'll begin with my discussion with a great scientist, Vikram Sarabhai. Said there are some who question the relevance of space activities, in developing nations. To us, there is no ambiguity of purpose. We do not have the fantasy of competing with economically advanced nations in the exploration and use of moon or manned space flight. But we are convinced that if we are to play a meaningful role in the community of nations, we are none to anybody in use of these space technologies. That is what, today we, Indian space program has moved beyond the imagination of, Dr. Vikram Sarabhai, what he visualized. But today, part of the Mangalyaan, Chandrayaan, all these programs, though he didn't say that we are not going to compete with economically countries, but definitely India has moved further, and today we are definitely competing, and we are best in the world in some of the space programs like remote sensing. India is doing extremely well in remote sensing. Our remote sensing technology is the best and also cheap and best, and also launching. These are certain things which are happening in the recent past, going back to the what. But when Indian space program started, it was thinking that being a developing country, poor country, do we need to spend so much of money in the space sector? That kind of divergent views or negatives were there. But thanks to the visionaries like Vikram Sarabhai, our first Prime Minister Nehru, all those they convinced, and they started our program, space program. And of course, initial stages, if you look at the space era began in 57, but we started our program in 63, early 60s we started. And when we started our space program, even we do not have had transportation vehicle. We used to transport this bullock cart. The entire global society laughed at India and saying that they don't have a transport vehicle. How are they going to manage the space technology? But today, friends, you all know that we have given a fitting reply to the people who laughed at us and people who used our thing. But I think we went beyond all these things, and 60s, 70s, we put our efforts building the infrastructure, satellites, and we have launched many things 80s and 90s. Particularly last 2 decades or 2.5 decades, if you look at, a lot of commercialization is happening. To do that, to continue the commercialization, of course ISRO also created its own department, that is Antrix, and also recently you mentioned in your introduction in space and new space things. These are all some of the things which are happening, and so this is the journey which I can say initial remarks, how India has traveled from initial stage to the recent present one. So that's my initial remarks. Okay.
Thank you so much, sir, for your views. I now call upon Professor Dr. Sandeepa Bhatt, sir, to provide his introductory remarks to the audience.
Thank you, Niharika. And also, I should thank the ULC for the invitation to be part of this particular panel discussion. But when I went through the program schedule, so I just saw actually 3 minutes given for the opening remarks. I was really confused with what should be spoken of, because I'm more comfortable with speaking for a longer duration rather than speaking for 3 minutes. That's one of the major problems. All right. Anyhow, so let me, as an introductory remark, probably let me tell you that actually there has been a lot of change in the space activities, right? So if you look into actually the developments in the 20th century, when the Sputnik entered into the outer space, or maybe the subsequent developments have taken place, during that time, it has been completely a science-oriented space activity which was going on. And more importantly, it was all the states who are basically carrying on the space activities.
for the purpose of scientific investigation. And the law which has been developed in the 20th century, be it you look at the General Assembly resolutions or maybe the 5 treaties, which are the only 5 available even till today on the space law. So they are all oriented more towards the regulation of the state activities in outer space. They predominantly tell about that, and also scientific the activities, whatever actually is to be carried on therein, common benefit, common interest. All these things are basically pointed out in the space treaties, which were developed in the 20th century. But with the realization of the fact that outer space can be used extensively for different commercial purposes, be it telecommunication, direct television broadcasting, remote sensing, weather forecasting, or telemedicine, teleeducation, so many things. So, I mean, there are so many applications of the space activities. With the realization of this, there has been a shift from the state-oriented space activities to the private sector-oriented commercial space activities. And we know that the space economy is immense, right? So if any country wants to come out of actually its economic struggle at present, space should be the final destination for them at present, actually. So that's why all the developed countries are trying in terms of exploiting the outer space resources. Not just that, there are also plans for using in terms of space tourism, and then maybe spatial data acquisition, so on and so forth. Different kind of commercial activities have come up of late. So major question at present is that whether this is a shift from the state-oriented scientific activities to the private sector-oriented commercial space activities, has it been properly regulated? If not, how should we go forward with the proper regulation to ensure that outer space benefits are going to percolate to everyone, right? It's not going to be confined to only select few developed countries, rather it would be beneficial for everyone. So that is the moot point, and probably we can discuss more on that with the questions in this the panel discussion. Thank you so much. I think it is very hard for me to stick to 3 minutes. Thank you.
Thank you so much. Even in the limited time, you have given a lot of important views of yours. So thank you so much. I would now request Ms. Deepna Gandhi, ma'am, to kindly provide her introductory remarks.
Yeah, good evening, everybody. Hope I'm audible. Yeah.
Yes, ma'am, you're audible.
Yeah, thanks for having me here. It's a pleasure to be among the distinguished professors. I'm hoping to add a little of technological perspective to whole of space and commercial sector. Maybe not the history, but how the current looks like and what it is to be working in the commercial sector. So those are some things which I can add. I'm hoping to add a perspective to the entire discussion, and it's a pleasure to be there. But sir, I will speak less, so I think we both will be a good combination there. It will not be 3 minutes even. Yani Harika, back to you. Thank you.
Okay, thank you, ma'am. Thank you for your opinions and words. Now we shall begin with the questions. So we'll take up prominent questions on the topic, and we're also inviting the audience to share their questions as mentioned in the chat box to Mr. Rohit, and we shall further progress from there. So with the topic at hand, the first question that comes to mind is that in what manner should the laws be framed further, or how can the existing laws be changed to cater to the increased participation or involvement for the private sector? I would like to direct this question to Professor V. Balakrishna Reddy, sir, and then we shall proceed from there.
Okay, if you look at existing legal regime with at global and also national context, international global context, of course. So we have treaties, particularly those treaties are developed in 1960s, whether it's an Outer Space Treaty 67, Rescue Agreement 68, Liability Convention 72, then Registration Convention 75, or MUN Treaty 1979. So the duration of 1.5 decade that. But if you look at the age or that time, more towards the public sector or government driven industry, actually state centric space activities used to be happened. That's why if you look at one provision of Outer Space Treaty, we call it a charter. I call it actually Magna Carta of outer space activities. I call it this. So even that Outer Space Treaty 67 there is a Article 6 of Outer Space Treaty 67 says that state responsibility, and 7 talks about state liability, only state. But today things have changed. A lot of space activities are done by the multinational companies, private individuals and private companies. Is it that relevant? Question comes, and a lot of debates, discussions are happening in the global fora also that this is not the relevant because today private participation is happening. So that's one major stumbling block when we talk about the current international regime when relating to commercialization of space activities. That shift has to be happened from state-centered to individual or companies, private companies. So state-driven industry to private-driven industry. That's one global context. Of course, even in India also, unfortunately, though we are doing extremely well in the space technology, there is no doubt that thanks to the dedicated scientists who have done wonderful work, proud of our nation. But when it comes legal thing, we are unfortunately lacking that. I can share my own experience when I was a student in JNU in 1996. I wrote first my article on space law and policy in India. Of course, no law, but I was studied few legislations, and then I wrote about that, saying that up to now there is no space legislation, but now time has come for India. I'm talking about 25, 26 years back. I said now time has come for India because commercialization, business activities are happening, and litigation is increasing. So there is a need for space law. And friends, thanks to all now lot of private other universities also taken up this issue. Now we are working, and government is very closely working on that. As a student, as a scholar, 2-3 drafts I gave my own. You can check in our books and other things. So draft legislation, this, that. So but today, of course, government has come forward, and they constituted a committee. We are all part of that, and space activities bill 2017 is pending. But one answer to all this, we are talking about privatization, private participation, level playing field. What is the answer? Answer is that we need to have a law, legislation. So that's my answer. So maybe once that bill passed, we can answer many questions. And today, when we talk about the privatization of space industry, it's a $1 billion business is going to happen. Without having a confidence, without giving a guarantees, who can invest in the space sector? So that's major problem because of absence of a legislation, which no private player can invest without having that. That's my view.
Thank you very much, sir, for your wonderful insights on that aspect. We would now like to ask a question on how could these legal regulations operate with regard to risks and liabilities in a more liberalized space sector? If I could direct the question to Dr. Sandeepa Bhatt.
Yeah. So I should say that the current regime is nowhere prohibiting the commercial activities. It's nowhere saying that the private players cannot enter into the market, cannot carry on the activities. If you look into the Outer Space Treaty itself, as Professor Reddy has pointed out, Article 6 of the Outer Space Treaty, while imposing responsibility on the concerned state, it also speaks about authorization and continued supervision for all activities, including the private space activities. So we should not be under the impression that the drafters of the Outer Space Treaty never foreseen a situation of the private activities starting. Right? They have foreseen it, but maybe in the faraway future, that's what they basically thought of. So therefore, there is a scope for authorization under Article 6 of the Outer Space Treaty, and state can basically regulate all the necessary requirements within the ambit of Article 6 while authorizing itself. Now, coming to the question of liability, that's under Article 7 of the Outer Space Treaty, which is also supplemented by the Liability Convention 1972. You have Article 2 and Article 3 of the Liability Convention, specifically speaking about the absolute and the fault-based liability. I should again say that we have got different models with respect to taking care of this liability or the risk with the private entities. Like if you look into actually the models in some of the developed countries, like say United States or maybe European states and all, we have got insurance, space insurance as a mechanism for the purpose of cushioning the liability. Right? To a greater extent, actually, they insist for the coverage of the insurance, which would help initially to take the liability, especially if it is within the particular limit. Like say, for example, European countries basically speak about $60 million. That's the 60 million euros. That is the limit of the liability, or that is actually the kind of insurance coverage maximum which need to be taken by a private company. Right. So, but while authorizing, they would say subject to this 60 million, how much is required for each activity depending on the risk. That much of insurance coverage has to be taken. The United States also similarly is having the norm of $500 million. Subject to $500 million, the concerned authority, while authorizing the private space activity, it has to say how much of the insurance coverage has to be taken by the private entity for a third-party liability. So like that, insurance is one of the models which is available with respect to cushioning the liability or the risk. But in one of my articles, which is available in the Athens Journal of Law, you can also actually look into it online, wherein I just probed into this third-party liability issue, and I have advocated for not for the insurance, rather for the space fund. Right? It's on actually space insurance. My article is on space insurance. So I just critically analyzed that, and especially from a developing country's perspective, insurance might not work. Because if you increase the premium, if you say it as a very high level of actually the insurance coverage, no private company is going to come up and they're not going to start the activities from our country. They will go for actually more conducive regime, wherever actually the liability norms or maybe insurance coverage is lower. So they will go for that. So that is why what is better is the space liability fund. And we have already experimented that in the nuclear liability. If you look into the CLENDA, Civil Liability for Nuclear Damage Act, we have already created a fund for damage caused by the nuclear activities. So probably the similar kind of a mechanism would help a developing country like India for the purpose of cushioning the risk as well as the liability involved in authorizing the private space activities. Hope that answers your question.
Yes, sir. Thank you, sir. So we'll get back to that point after we just asked Ms. Deepna Gandhi, ma'am, a particular question. So considering that Professor Bhatt, sir, and Professor Reddy, sir, have already given their insights from a legal perspective. Now, as a private player or as a person who's working in the field, what confidence can entrepreneurs take, while entering into the business of the space sector? So from the person who will be subjected to these laws, how would they implement your working?
So yeah, from a technology perspective, what I could add is like if we want to truly thrive in private sector, the law and regulation must enable them to perform, or like it should enable the private player to be part of this ecosystem effectively rather than pose a lot of hurdles. For example, if there's for a private player, IP is the core of any startup. So it is an asset of any company. So in such cases, if there's a law which, if law is not allowing to do such a thing, then that becomes a hurdle. And also simplification of the process will help. Another example there is like if universities, for a university to launch a satellite, university should not have to go through the same lengthy process as large industrial organizations have to do. So if these things are simplified, that enables private players to enter. So law and regulations must balance the interests of different stakeholders. If such things are done, that enables. And from a technological perspective and innovative perspective, I'm sure like India is doing pretty good. When I started, there were hardly 2-3 startups. Now there are so many startups doing in various sectors of space, like launch vehicle, small satellites, data analytics, and also optical communications. So some of them are like really innovative technologies, be it on the forefront of AI or like on the hardware technology. So these are some of the things which private players are providing solutions to. So yeah, so that's in addition to whatever they told.
Thank you very much, ma'am, for providing a more different insight on the aspect related to the privatization of the space sector. So moving on, we would like to question Dr. Balakishna Reddy on how the current SATCOM policy governs the private sector in India and what kind of changes could be recommended for the same.
Not only SATCOM policy, but generally, if you look at the policy, I mentioned, having a law policy to some extent limitations, like, when private, whether it's a SATCOM or other technologies, not having a legal backup, like I mentioned, I am again reiterating that policy has only day-to-day things and policy can have, but problem with Indian space program today we are encountering and various facets of space program, whether it's a satellites or again launching and other remote sensing are. So my view is that we need to have a comprehensive law. Of course, law won't discuss details, all these things. At least you have a basic framework. Under that, you can come out with policy guidelines, rules, regulations, all those that will help. We're not taking into SATCOM policy or simple policy in isolation. So we need to have that comprehensive thing, and these are all part and parcel of the various stakeholders. So that's my view, is that we need to have a comprehensive law that can take care of the existing issues instead of piecemeal or bit and piece, like that. So my view is that need comprehensive law touching with, of course, again, law, policy, rules, regulations, there are variations, but if you have a basic thing based on that, and second thing is she was mentioned today, of course, level playing field is very much required. When we are private public, there are examples we can take with try or otherwise in airports. Earlier we used to have only government airports, okay, public airports, but today private airports are there. So to give the level playing field between the both public private, we came out with the legislation that's the ERA Act, that's called Airport Economic Regulatory Authority of India Act, that oversee the both public private. Similar things also we can think of when private participation is there, then we can bring out the regulator. Why regulator? Because of private participation. Earlier it was only state driven, no regulator required. So once things happens and trade off, then definitely we need to have independent regulators, and we can take experience of other fields, like I was mentioning telecom and airports and other things. Similar thing we can do in the space sector or the SATCOM sector also.
Thank you so much, sir. So before we move on to the next question, to the next panelist, I just have a follow-up question. So considering what was stated by Professor Bhatt, sir, that is regarding a space fund. So as your role of, in policy making or recommending legislations to the government, laws to the government, how would you say we can introduce such a space fund to the existing norms that exist to govern space sector? Professor Reddy, sir.
Professor Bhatt, you asked Professor Bhatt, space fund he was mentioned.
No, sir. Yeah, regarding what he said, I would just like to know how could, from your perspective, how could that be implemented in the space sector, like at the moment?
Space fund you are talking about?
Yes, sir.
Space fund, of course, to encourage the private people to give confidence in private sector, and that may we can, but is it going to work? Well, solution, is it going to happen? So why now public to private is happening? States, government does not have so much fund and we have other priorities. So in realistic thing, can we think that, space fund is going to create? So things now, other way is happening. In that context, actually, is it that fund is we are going to create, or is it going to a reality? I don't know. Of course, to encourage, we need some fund, some, everything is linked with the money. Okay, when you want to, startups, Madam was mentioning about startups, all those, of course, Startup India program we started, way back, 2014-15. Now today, startup is, happening all the sector, including the space sector. They are talking about the fund. So maybe similar thing we can experiment here. But other experience I can, give example is startups. Startup fund they created. Government of India, part of Make in India, Made in India, Skill India, Digital India, all these, now they are venturing into the startup system, and space, defense, these are also happening. So if, fund, if you ask me, similar, idea we can move what now Government of India is extending to startups. That's my, take on.
Thank you so much, sir. Professor Sandeepa Bhatt, so before we get to your response to what was stated, I would now like to welcome and acknowledge the presence of our Honorable Vice Chancellor, sir, Professor Dr. Professor Dr. Venugopal, sir. Thank you so much for gracing our occasion, sir. Would you like to address the gathering?
Thank you, sir. Thank you very much, Sir Venugopal, sir, for joining. Our Honorable Vice Chancellor is an eminent academician. He is basically a professor of computer science. He has contributed published more than 700 articles and more than 70 books, authored more than 70 books. And also he has several patents to his credit. He is an eminent academician and also an able administrator. And our Honorable Vice Chancellor, we have in Law College special blessings of our Honorable Vice Chancellor. Whenever we request him, he will be always there with us and guide us. And despite his busy schedule, as I mentioned in the beginning, he was very busy with the NEP implementation program. But despite that, sir has joined us. Thank you very much, sir, and hearty welcome, sir.
ನಮಸ್ಕಾರ ಎಲ್ಲರಿಗೂ. ನಾನು ಇಲ್ಲಿ ಕಾರ್ಯಕ್ರಮದಲ್ಲಿ ಇದ್ದೀನಿ. ಆಕ್ಚುಲಿ NEP ಹೊರಗಡೆ ಬಂದಿದ್ದೀನಿ.
Yes, sir.
ಮೀಟಿಂಗ್ ನಡೀತಾ ಇದೆ. ಐ ಆಮ್ ವೆರಿ
There is some network problems, sir.
Your program has gone that in short of time. Ministry says that I wish you all the best, and I'm very happy. Are you able to hear me?
Yes, sir. Yes, sir. Now it is clear. It's not audible, sir.
I am actually in the program. Actually, there is a minister is addressing, but still.
There's a lot of disturbance, sir. It's not audible, sir.
Are you able? Are you? Hello?
Now it is okay, sir.
Are you able to hear me?
Now it is clear.
Yeah. So I'm very happy that you're conducting such a program. I'm busy with the NEP, National Education Policy, and I'm in the subcommittee to make the assessment. Now the internal assessment will be 40-60, 40 internal and 60 examination. It is a revolutionary change. Actually, it will bring about a lot of changes in NEP. And I'm very happy that today you are conducting this program, and thank the University Law College for inviting me to the program. All the best. Professor Suresh Nadagoda, Sudesh, Dasharath, Satish, Jyoti Venkatesh, and Chandrakanti. Thank you very much. And thank you all my students. So can I take leave now?
Sir, we have three experts, sir. One is Sandeepa Bhatt from National University of Juridical Sciences, Kolkata, and we have Professor Balakrishna Reddy, registrar from Nelsar, an eminent academician, both of them experts in the area of space laws. And we have Deepana Gandhi, who is also an expert in this area, sir.
So thank you, Deepana Gandhi, Balakrishna Reddy, and Sandeep Bhatt.
Yes, sir.
Thank you very much for participating in this panel discussion, and I am very happy that you have given your time, valuable time, to our Bangalore University. Thank you, one and all.
Thank you, sir. Thank you, sir.
Thank you.
Okay, you can continue, Niharika.
Sure, sir. Thank you, VC, sir, for addressing the gathering. Now I would like to hand over the floor to Professor Bhatt, sir, to reply to the statement given by Professor Reddy.
Thank you, Niharika. In fact, actually, my proposal has been entirely different. So the way in which actually I argued in my paper has not been actually a fund to be created by the state. It is not actually the space contributed fund. Rather, it is a fund which is going to be contributed by the private sector itself. Right? So out of the profit, whatever they're going to make out of the space activities, so they have to contribute a particular portion to this particular fund. And why I am saying this as a better model than the insurance is that in case of the insurance, you have got a third company, the insurance company, right? So whatever premium you're going to pay to the insurance company, every year it is going to vanish. You're not going to grow it. There is no possibility of actually say, whatever, suppose if a company is every year it is paying a premium of hypothetically say 5 lakhs or 10 lakhs or 20 lakhs, whatever it may be. So depending on the nature of the space activity, if they're paying a premium of 20 lakhs, that is gone. Next year, they have to pay once again. So you have a third company, an insurance company, which is profit oriented. And ultimately, whatever premium you're going to pay is going to credit to them. But whereas if we are going to pay the same premium to a fund, the space liability fund, there is no extra burden on the private company, because what they are supposed to pay as an insurance premium, they are now shifting it to the fund. That's it. Nothing more than that. Right? So unless the liability claims are made, this liability fund is going to grow over the period of time. It's going to grow. Suppose if there is no accident for next 20 years, right? Hypothetically, there is no accident. Or of course, even if accident is there, no liability. At the end of the day, liability is the more important thing. If there is no liability, after 20 years, we will be having a mammoth fund for compensating any victim, right? And there is no requirement of a private player becoming bankrupt out of the accident. This has been very well successfully done in the United States in the nuclear liability fund already. They have got a Price-Anderson fund, which they started in 1958. Price-Anderson fund with respect to the liability norms, nuclear liability norms, and it has got now more than $15 billion. More than $15 billion for compensation to any victim. Right? And apart from that, they have also actually planned another liability fund regime in the international level through the Convention on Supplementary Compensation. 1997, they went ahead with the Convention on Supplementary Compensation, wherein for the cross-border victims, they are also creating an international liability fund by contribution of all member states, not by the state fund. It is from the operator's fund. Whoever is operating the nuclear or the reactor, they would be contributing, not the state. It's not the payment from the state. So, of course, if the state has to pay, it becomes a higher burden for a developing country like India. So the model is not on the basis of a state contribution, rather it is by the private players contribution only. And it is also not an additional burden, since instead of the insurance premium, they're going to pay the same amount out of their profit to the liability fund. But one thing, the state has to administer the fund. Fund is not going to be administered by the private players. The state has to administer the fund. Only the administrative responsibility should be with that of the state. And in case of any kind of a major mishap, compensation can come from the liability fund.
Similar thing, of course, what Professor Bhatt was saying, we have experience, of course, not successful, future maybe. There is this outer space is a global common. You all know that, anything is coming from, global common, because everybody has properties like res communis, res nullis. Space is a res communis, community property. Every state has a claim, or every stakeholder has right. But are we today using the entire space? I mean to say that only 50-60 states have taken advantage of space activities. What about 150 states? What is there? Because this belongs to them also. So that idea was there in Law of the Sea. Like we have a common heritage of mankind. There is one principle it was there in the Law of the Sea. Of course, space law also borrowed that. Article 11 of the MUN Treaty actually talks about that Moon and other celestial bodies or natural resources of Moon can be common heritage. We'll wait and see how, when we states are exploring that technology, all those things, it may possible. But these two examples, we can say international context. One is the Law of the Sea, other one is MUN Treaty, specifically talking about the Moon resources can be given to some extent, what Professor Bhatt was mentioning about private thing. But this is the other relevant point I thought, I'll bring to you. Thank you.
Thank you, sir. So now my question would be to Deepana ma'am. Ma'am, considering that you are working in the private side of things, how do you think the private sector would respond? Like, how willing would they be to contribute to such a fund and be a part of this new initiative?
So currently, not looking at India, it is none of the startups, to say all the startups are in an early stage. So none of them have entered into a sustainable business model yet. So in such a situation, I think getting funding and making it a sustainable business would be the prime objective of any startup. So once the cycle of revenue and everything starts, then I think they would be willing to do. Till that, I think the struggle is to get into a sustainable business model and get the rig started. So yeah, I think we are very far away from getting into those still.
Thank you very much, ma'am. I would like to ask a question. When Sir had mentioned, Balakrishna Sir had mentioned about how the common heritage law that is being prevailing right now in the space law. So how does this aspect, or how does this happen in regard to the wake of liberalized reforms? Is there any evident or anticipated risks with regard to the common mankind question when it comes to a liberalized space reform? If Dr. Sandeepa Bhatt could answer this question.
That's great. I was thinking that you were asking it to Professor Reddy. I mean, I'm really eager to answer this because my PhD has been on the common heritage of mankind, right? And I worked on actually the MUN agreement itself, to be very precise. First of all, let me tell you that as Professor Reddy has rightly pointed out, common heritage of mankind has not been well established in space law. It has been rooted very well in law of the sea. He pointed out specifically about the law of the sea convention, actually. Because under Article 11 of the MUN Agreement, right? Okay, right. So under Article 11 of the MUN Agreement, even though the concept of common heritage of mankind has been incorporated, and you have a very, very detailed provision, you can find 8 paragraphs. Article 11 has got 8 paragraphs explaining what are the different components of the CHM which should be applicable, and how exactly some international regime has to be developed for the sharing of benefit, so on and so forth. All those things are mentioned in Article 11. But unfortunately, what has happened is that the developed countries have never accepted the common heritage of mankind principle. Even in the law of the sea, only United States basically rejected it. And unfortunately, there's a basic problem because in the law of the sea, for the deep seabed exploitation, common heritage of mankind principle came into existence. US is outside the UN clause, UN Convention on Law of the Sea. So that means major technology for exploiting is outside the Law of the Sea Convention. The major country which is supposed to exploit it is outside that. So that's why the problem is there in the law of the sea as well. But it is more prominent in space law because the MUN Agreement has been signed and ratified only by 18 states even till today. 18, not 80, 18 states have ratified the MUN Agreement. Out of them, many of them are not even spacefaring nations. They are not even spacefaring nations. Only 3 states, Australia and the 2 European states, the 3 of them are having the space activities. And unfortunately, all 3 of them are not having activities in the moon and other celestial bodies. Of course, now the European Space Agency is going towards the actual celestial bodies, but until now they have activities only in outer space. And the MUN Agreement is applicable to the moon and other celestial bodies, not to the outer space per se. Common heritage of mankind under Article 11 is applicable only to moon and other celestial bodies, not to our, say, medium Earth orbit or the low Earth orbit, whatever we basically speak of. CHM regime is not applicable there. That is the basic problem of application of the common heritage of mankind in space law. Now, I think there is also a question with respect to the private activities, whether the private activities would be in consonance with the common heritage of mankind regime. That's what actually is one of the basic questions which has been asked to me. I should say that common heritage of mankind never says that you should not go for exploitation. It is not a regime of actually a moratorium. No exploitation by the private players. No, it allows it, right? There is an explicit allowance for that action. Only thing is that the whoever is exploiting has to adhere to the principle of sharing of benefit, equitable sharing of benefit, right? It is also not equal sharing. Please keep in mind. And more importantly, benefit. It is not actually say whatever you get out of the space activities, you share everything with everyone. No, because you have got a huge investment. As a startup company, or maybe a company which has done so much of research and development, invested billions of dollars, it doesn't mean that whatever resources they bring back, they have to share with everyone. Not like that. So it is only profit or the benefit derived out of the exploitation of those resources, which should serve the interest of the mankind as a whole. That is about the concept of common heritage of mankind. But unfortunately, most of the developed countries misunderstand that. They're under the impression that everything has to be shared, including technology has to be shared. No, common heritage of mankind never speaks about technology sharing. Right? As advocated by Arvind Pardo in the Law of the Sea initially, and then subsequently by the Argentinian delegate to the United Nations, Aldo Armando Coca. Right? So both of them never say that actually you share everything. It's only benefit or profit derived has to be shared equitably amongst everyone. So I don't think the common rights of mankind in any way prevents the exploitation by the private entities. Only thing is benefit sharing, and also another important thing is conservation. Right? That's also conservation for the future generation. That's also need to be followed while carrying on the activities of exploitation.
Okay, in continuation, a minute, actually, continuation of Professor Bhatt. There are three issues: global commons, common concerns of mankind, common heritage of mankind. Global commons are these things. Common concerns is particularly protecting the environment. You have, you can use, but you have to use that in a prudent manner. That's where, second, global common concerns. This, the third principle is continuation of that common heritage. Okay, so thank you.
Thank you so much, sir. So keeping that in mind, we've got a question from the audience that is, what is your opinion on the need for terrain settlement laws in view of the rise in space exploration and such settlement projects? So this question is open to all the panelists. So whichever panelist would like to prefer to answer it first, they may.
Okay. So generally, again, I'll look in a little broader way. The problem with the law which we are talking is a technology, space, technology or any technology. The law and technology have a very much, very connection. The linkage between law and technology, the connection between law and technology is not so, easy, uneasy actually. Technology is moving fast, okay, but unfortunately, law is not catching up. But definitely law and technology have to go together. For example, I'll tell you, our own. And 4th, October 1957, Sputnik launch was happened, and so after that, so much development is happening actually. So man, moon, landing moon, and international space station, space hotels, all these things. Today, I can tell you, again, with all this, we have entered a new era of solving the problems of Earth, using space technology. There is no doubt about that. But when it comes to legal side, law, unfortunately, it is not catching up. Though it begins the moment when I say 4th October, 14th November, exactly 40th day, United Nations General Assembly came out with a resolution urging the countries to use this technology for betterment of humankind. No, but is it happening? So generally, my view is that, this is the problem where technology moving one side faster and the law is not catching up. In this gap, societies are facing problems. That's my view.
Thank you very much, sir. We have another question from the audience, which was, yes, sir, definitely, sir.
Right. Right. I mean, you mean to say about the celestial settlement, right? Terrestrial settlement in the sense that celestial settlement in the same moon and other celestial bodies. Coincidentally, it happened to be the topic on which I spoke in the last International Astronautical Congress. Right. So, so it is also on actually the celestial settlement itself. Again, there is a problem with the celestial settlement, especially because of Article 2 of the Outer Space Treaty. If you go through Article 2 of the Outer Space Treaty, it categorically says that there shall not be any national appropriation by claim of sovereignty, use or occupation, or by any other means. There is a specific reference to that. There should not be any national appropriation. Now, question is, how do you interpret this? Are you going to interpret that only the states are prohibited because it speaks about national appropriation? I, as an individual, can I go and settle therein? Can I claim a property right? Right, because it speaks about national appropriation is prohibited, maybe by claim of sovereignty, use or occupation, or by any other means. That's what it basically speaks of. Right? There is no explicit mention about a prohibition on a private entity or a private player going there into the celestial bodies, settling therein, and claiming the property rights. However, a prohibition on national appropriation under Article 2 also in turn include a prohibition on individual appropriation. Even a private player cannot go and settle therein and claim that this is my property. Because for that, we need to understand actually the allocation of property in both common law system as well as civil law system. In common law system, we have the principle of eminent domain. State owns everything, right? All of us actually would get only the grant from the state. So if the state is not owning anything by virtue of Article 2, definitely my state cannot give anything as a private individual. So from India, we can't go there and say that this property belongs to me, because India cannot claim any kind of a property right or a sovereignty over the moon or other celestial bodies. So we can't do it from a common law system. In the civil law system, there is a slight difference in the allocation of property, wherein there is no concept of eminent domain. They don't believe that the state owns everything. There, an individual has to go and occupy a property which is terra nullis, which does not belong to anyone, right? Something which does not belong to anyone, one can go and occupy, one can develop it. Once it is developed, the concerned country would recognize the labor, whatever has been put in the development, for conferring the property right to the individual concerned. So it is the labor which has been put in for development that is recognized, and the property rights are conferred to them. Even if you apply this logic, an individual from the civil law country also cannot claim property rights in the celestial bodies, because celestial bodies are not terra nullis. They're not res nullis. As Professor Reddy has pointed out, they are res communis, or a variant of a res communis. You can find under Article 1 a provision called Province of All Mankind, Article 1 of the Outer Space Treaty, which is the variant of the res communis regime. It's a res communis. So therefore, when it belongs to everyone, we can't go and occupy it, and we can't say that this belongs to me. So therefore, I should say that extraterrestrial occupation and claiming the property rights would all be problematic. And even Article 1 says that everyone should have the freedom of exploration, use, and scientific investigation in every part of celestial bodies. So your individual rights or occupation would also come in the way of that freedom. So these are the concerns with respect to.
Okay. In continuation, I mean it actually what Professor Bhatt said. Yes. And unfortunately, we are again students of space law, both Professor Bhatt and myself. But some countries, now developed countries, they are making legislation and they are started claiming. Of course, legally they are not valid, but countries like United States. Unfortunately, that is the happening actually. Though legally speaking, they don't entitle at all, but certain things are happening. That is the danger to the global society, because it belongs to everybody. So thank you.
Yeah, I think that should have been a follow-up question actually. Unfortunately, current scenario is that there has been an individualization. You can see that, as Professor Reddy has pointed out rightly, United States in 2015 has come up with a law, asteroid mining. The 2015 US legislation on the Space Act, that permits the asteroid mining. Not just that, even a private player can also claim property rights over the resources, whatever has been exploited. That is really a concern, because it's an individualistic move from a country which already agreed that it is the province of all mankind. So it is a complete reversal of a process of the common rights regime which they have accepted in the 20th century. And now they are saying that, oh, we have a technology, let us exploit it. It's a situation like that. And unfortunately, Luxembourg has followed it. 2017, Luxembourg came up with the law, passing the similar kind of the norm. 2020, United States has come up with the Artemis Accord with respect to going back to the moon and exploiting the resources therein. And they have called for cooperation from different countries. So I don't think none of these are in conformity with the international treaties, whatever have been agreed, including themselves, including the United States. That's the unfortunate state of affairs.
Thank you, sir. Yes, sir. So considering what you've stated now, we would like Deepna ma'am to kindly give her perspective on this, considering that since on one hand we have the lawmakers, and then we also have in this panel someone who would be subject to this law. So from her perspective, what would she think is the change, or the change in dynamic that has been brought about, specifically in India in the past few years?
I think I'll have very little to add on this, because I think most of the things are very old here on mining and other things. None of the countries in India are working on that currently, but definitely there are companies working on moon landing and other things. So I think I'll have very little to add on this. So I'll skip this.
Okay, thank you, ma'am. Now we proceed to the next question. That is, so now the speakers have provided their opinion on how the law has to change, and also in what manner it should progress from here. However, we would want to know what are the issues or the problems that can arise from such liberalization reforms. So keeping in mind risks like data sharing, or considering that the information collected by these private sector companies, if they will be commercialized, if such information, which is, as stated, supposed to belong to everyone in general, if it costs more, or such policies that may come into being, which could cause threat to national security or other national interests. So what are the issues and how can we overcome these issues? So I think we request Professor Reddy sir to address this first, and then we'll move on to the next panelist.
Yes, definitely. Now we are talking about current developments, globalization, liberalization, privatization. All these things are happening in the general context also. Of course, space industry is no exception. Globalization is happening in the space industry, and particularly developed countries are today, globalization, part of commercialization, privatization. There are certain issues which are coming up. For example, security versus commercial issues, commercialization versus security. Then, private versus, again, privacy versus, confidentiality, like private sector versus government. Then we have, all the copyright, IPR issues, and, these are the issues which, again, whole some comes into picture when we talk about liberalizing or we can say, unlocking the space sector for private people actually. So these are all issues bound to come. So particularly like what are the international regimes are there? Okay, for example, so remote sensing, we are talking about, there is a 1986 remote sensing policy clearly laid down that what are the rights and responsibilities of sensing states, confidentiality, data protection, all those things. But to follow up that again, international law, one thing I can tell you all viewers also, international law or international space law does not have its own machinery. The problem with comparing the domestic, and I want to make, clarify you all that, when we are discussing something on international context, please understand the limitations of international, execution or internet. So in the domestic, context, we have, certain institutional setup. The domestic law is backed by, implemented by institutions like Parliament, legislature, legislate, executive, implement, judiciary, interprets. Do we have these things in global context? Have you heard something called World Parliament? Have you heard something called World Executive? Though, you all maybe heard about World Judiciary, ICJ. But friends, I can tell you that ICJ also gets jurisdiction based on the consent of the state. Consent is important. That too voluntary consent. Why voluntary consent? Because we are talking about, sovereign states. So these are certain limitations. That's why general context, we again, as a teachers or students, when we discuss international issues, please understand that limitations, because it is not above. We do this is no supranational authority. Every state is a sovereign themselves. That is, that context actually, we have to have a self regulations, and we have to follow when you are entering into any treaty, whether it's a MUN treaty, outer space treaty. We need to have our own legislations. That is where the India or any country, we have to implement. India follows dualistic approach. We believe that international and domestic law are two different distinct things. If that is the case, then implementation of international space law, and of course, unfortunately, we don't have in the space segment. But I can give you example of aviation. India is a party to the Tokyo Convention, Hague Convention, Montreal Convention. To implement that, we have a Tokyo Convention Act 1975, Hague Convention 82, unlawful, like that. But here, the problem, with space or space legislation, though India is a party, India is ratified, except of course MUN treaty, other thing. But what about the legislation? So that is the constraint comes. That is a problem. These are all well established legal, regulations provided in the international regimes, whether it is a soft law or hard law. When I say soft law, it is actually, UN General Assembly resolutions. Like, we have a direct broadcasting, resolution on DBS, resolution on remote sensing, resolution on nuclear sources, all. We have a treaties. But, that is the limitation we have in Indian context actually. So we do not have a enabling legislation. That is where we are having a problem. So that's my view on that.
Thank you, sir. Professor Sandeepa Bhatt, sir, would you like to share your views on the same question?
Yeah, definitely. I might not have actually any question for which I don't have any view. Sorry for that. Really sorry. Right. So if you speak about actually the issue of multiple issues which might come up in terms of opening up the economy or going for the privatization, I should say that the first issue is the state responsibility under Article 6. Right. So if you go through Article 6, it says that straight away a responsibility on the state for every activity, whether it is carried on by the governmental entity or by the non-governmental entity. So it is a kind of a responsibility different from what you find under the public international law. Because under the public international law, state is responsible only when it has authorized a particular private player or a particular individual to carry on an activity. You must have heard about the notion of imputability. The notion of imputability, that is the essential element for imputing a wrong to the state and state being responsible for it. But Article 6 does not adhere to that. Article 6 simply says that whether it is actually governmental activity or private activity, the concerned state is responsible. So authorization and continued supervision under Article 6 has to be the first issue to be taken care of by the state. Second aspect is the liability. Again, Article 7 fixes the liability on the launching state, not on any private entity. So suppose if a satellite falls over another territory, another country's territory, causes damage therein, that victim state is going to proceed against the launching state, not the private entity. They will claim the compensation from the state. So money would go from state exchange. So that has to be taken care of. Maybe, as I said, insurance or liability fund, whatever it may be. That's the second thing. Then third, IPR issues, intellectual property rights. Especially we are in an era wherein we are going to have more and more inventions in outer space. So how to regulate it? Can we grant the patent? If there is an earthly patent which is violated in outer space, how do we try this? Which court has got the jurisdiction? Which law you are going to apply? They're all debatable. Then you have issues of property rights. If individuals go there, like say, there are people who are selling the parts of the moon and other celestial bodies. There is a person by name Dennis Hope. He has a website called lunarenbassy.com. Since the beginning of this century, I'm telling about more than 20 years, he is selling the parts of the moon and other celestial bodies to people across the globe. Go through lunarenbassy.com, www.lunarenbassy.com. More than 7 million people have purchased it, all celebrities. How to regulate these kind of activities? So that would also be one of the biggest questions. More than that, if you speak about the aspect of security, state data security, of course, one of the major issues, all of you must be knowing about it in common. Another thing is that suppose if actually there is a financing from other countries, there are financiers for a space activity from other countries, and a debtor is carrying on activity in hypothetically India. After actually the activity has started, if the debtor fails to pay back the money, the financier is going to proceed against the debtor. And only asset available is the space asset. Right? So there would be the in-orbit transfer from one company to another company, an Indian company to another company, which would open up a lot of security issues. This company might have been hired by the government for some security reasons, security purposes. Some services might have been rendered. Right? So those confidential data, which may be there within that, might have been transferred out of actually this in-orbit sale. So that becomes one of the major problems with respect to the security. Right? Of course, there are multiple other things, so many issues, even space tourism for that matter. It opens up a different horizon. You would be having the players from different jurisdictions, 10 different, say, tourists from 10 different countries. They've been launched from India, hypothetically. And the operator is from actually, say, SpaceX, United States. They are going to carry on from India. They're launching from Indian facility because it's cheap, hypothetically. Whom are you holding liable if there's any kind of a mishap? Because India becomes a launching state, US becomes a launching state, and multiple other states to which all these people who have financed, they might also become launching state. Who is liable to pay the compensation? Right? So that would be plethora of issues which would come up. I mean, if I have to rank them, I don't know how to rank them in terms of the sequence, because all of them are equally significant problems.
With our discussion with regard to the risks and the problems associated with the commercialization, I'd like to also bring in Deepana ma'am to answer if the permitting of commercialization is an incentive to private players, because we have seen a trend over the years where such commercialized data or benefits slowly gets democratized. So if you could please elaborate on that, ma'am.
Yeah. Before that, quickly, I'd like to add an example for the problems which are there in the, like whatever they're telling about data security interests. So as Reddy sir and Bhatt sir pointed out, if the laws and regulation for space activity are more clearer, I think that can avoid a lot of problems. So one such example from recent launches, I would like to bring it up here. So there was this launch by ISRO, which was a shared launch of 31 satellites, which was done recently. So there was there were 4 satellites in that. These are small satellites. Those are size of a palm. So these satellites were called Space Bees. So these satellites were from a US company. These 4 satellites were the size of a palm. So these satellites were denied by US FCC. They were denied, telling they are potential hazards. So those were denied by US FCC, but then they launched with ISRO, and that's like, such things are loopholes in law and regulations which are causing problems. So those were launched from India, PSLV, and then they came to know that these satellites cannot be tracked from Earth because they're very small sized and they are potential hazards. So that was one such example of potential problems. Yeah. Next, can you repeat the question?
Yes, ma'am. Keeping in mind that commercialization of these the space sector, it slowly turns into a more democratized space. So what is your view on that, ma'am? There's a trend that it slowly turns into a more democratized space.
So like emerging private sector, it will enable the current whatever ISRO, or it will focus, so that will help ISRO or the existing big players focus on cutting edge technologies, and the already existing technologies can be outsourced, and that can help the private players in development and other things. And I'm sure NASA has been doing that. They've been outsourcing a lot of their work. For example, the cargo to ISS, those are supplied by them, by SpaceX. Private players are doing that. We are far from doing all that, but I'm sure we're getting there.
Thank you, ma'am. A short follow-up. So as per what you previously stated, in your opinion, to what extent should the private sector companies be responsible and liable for the benefits that accrue from their missions and projects?
I think it's very double-edged question. It depends on the objective and the mission. If it's a completely private entity, it is operated by the private organization, then it is owned by whatever data is generated, it's owned by the private organization. For example, any of the small satellites which are launched are operated by the private players. And all the data which is coming out of it is owned by the private entity. And when it comes to collaborations with the bigger organization, then I think there will be clear divisions. For example, SpaceX is collaborating closely with NASA, and they're working on very crucial missions, which are like, recently there was a human mission which was tested. Now SpaceX is taking a crewed mission. They're doing it for NASA instead of the traditional way of doing it. So I think it's a collaborative effort where the existing bigger government organizations collaborate with the private organizations and take it together forward. So
to continue in July 2018, ISRO has signed 3 big companies to build 27 satellites, part of this program. And the second thing is that these are all how to share liability, responsibility depend on the contractual agreement. What kind of like when you are getting benefit, of course definitely you have to share the responsibility of liability issues depend on the agreements they have.
Yeah, great, sir.
Thank you, sir. Thank you, ma'am. We would like to ask a similar question with the same lines from one of the audience members, who stated that Neil deGrasse Tyson, an American astrophysicist, said that the first person to successfully mine an asteroid will become a trillionaire. So if that is the case, not all countries will invest in their space research organization to achieve the same. And how do we regulate such actions that would ultimately lead to a race between the countries of the world and take itself a monopoly in space resource? Would such a country be subjected to or follow international treaties or laws? Would there be any repercussions? This is open to all the panelists.
Professor Bhatt, you want to address? Okay.
I will follow after actually you address. Yeah.
Okay. So this is mining and also monopolizing these things actually. Of course, it's going to be very difficult. Already we have seen our experience. If you look at space journey, started with two superpowers in late 50s with US and militarization, security part of that thing, and later on, of course, percolated into commercial and other things. Of course, today countries are again individual companies also going to talk a lot on because lot of resources available in the moon and other celestial bodies, moon mining, these are all going to be the futuristic issues. But definitely, of course, if company or one individual is going to extract those resources, but as per again law, the existing law, it won't permit. Of course, there are some certain things are happening, like Professor Bhatt was mentioning, but legally speaking, of course, nobody to own, to explore, to exploit those things. First, you have to own. Are you owner of that? First question comes, no. Legally speaking, of course, you can make legislation. Sometimes might is right. Some developed countries are using this thing, but it is not going to that is not the right thing. So that is as again we can say. So this is my view, and of course, I don't think that is proper. There are certain issues. One thing you have to again remember, friends, when it comes with international law, again international space law. Space law is more effective, or general international law is more effective when it comes developing less developed countries. It is ineffective when it comes powerful developed countries. This is a flaw in the system itself, because nobody is above. Sir, if America is doing wrong things, can we take action? Is it really? Can we have a procedure to take that? So that's why it's a system. I am not saying that the developed countries should be victims or no problems, but as of now, if you look at the practical side, this is happening. Most of the time, we are in disadvantageous position. I mean, so the majority of the developing countries, and developed countries are exploited. So these.
Yeah, if I may continue from where Professor Reddy left. Yes, absolutely. It's very, very difficult to actually bring the big brother into the hooks, right? So especially the United States, it's going unilaterally, and there is no possibility of actually containing them. 2015, actually, once the United States came up with the legislation for this mining of the asteroids, they had got actually two arguments. One, that Article 2 prohibits national appropriation by sovereignty and all. It is just the exploitation of resources. Once they exploit, they can claim a right. That's one thing which they said. Second thing, they also argue that these asteroids and meteoroids are the smaller ones, and they're not the celestial bodies. They're not the celestial bodies. So Article 2 is not prohibiting any exploitation of them. I don't know whose interpretation it is, because it has been defined. Historically, whatever body is there in the outer space was considered to be celestial body, right? So when the Outer Space Treaty was entered into, or maybe Moon Agreement was entered into, nobody said that we are going to segregate the bigger ones from the smaller ones. They didn't do. But now US says that only the bigger ones, they are the celestial bodies. Remaining all are unholy, so we can exploit them, right? So that's a kind of an approach which they have taken. But then fortunately, international community is also trying to respond to that. There is a group, there is a Hague working group. There is a Hague working group on the space resources, which is a consortium of all the top universities across the globe. And you have the best of the best space lawyers who are part of it. And they're trying to counter the US position, the US individualism. They're trying to counter that through the Hague working group. But I'm pretty sure that they will not be successful, even though actually they're going to try their best. But United States has never been a state to agree to any of those actually advices. They've always gone unilaterally, be it in the law of the sea or be it in the space law. So it is going to continue, and probably a wrong precedent has already been set by the United States. So it would be very difficult to contain and say that we will bring the regime of common edge of mankind. You share the benefit. It might not happen in the near future.
Thank you so much, sir. Ms. Deepana, ma'am, would you have any views on this particular question?
No, Niharika. I think it's fine. It's very futuristic in terms of technology, in terms of other enhancements. I think it's far away in the future.
Yes, ma'am, before we move on, there's a question posed to you in the chat box. by the audience. Ma'am, what is your inputs on the actual impact of liberalization of the space exploration and analytics on startups focused on space exploration? Whether it is a boon for going ambitious or whether it is a bane in increasing competitive arena, creating a spatial race?
Yeah, so if I understand the question, it's about, can you repeat the question? Your audio broke in between.
Sure, ma'am. I think in short, they're just asking whether the current liberalization, would it be a boon? That is, would it help in increasing the ambition of going to space and increasing the knowledge regarding the same? Or would it be a bane, creating a competitive arena, leading to a spatial race type situation that causes more harm than good? That is what the audience is.
So we as human race, we've always been these curious creatures who always want to learn about things, and that curiosity is what has brought us to this point of exploring our Earth and moving out of Earth and going to other planets. So optimistically speaking, I think it is a boon, because if things are done collaboratively, it is a boon. Even now, what we're doing is, when we are developing a system, it's sometimes it's indigenously made. Even if it is made here, we are looking out for components of the system from all across the globe. We are buying things from, when it is a private player doing it, we're buying systems from all across the globe. So when it can help in collaborating, and when it is private players, one dependent on the other, one is helping other player to generate revenue. So it's a cycle. So in that way, it helps each other build together. So moving forward, if we are together and more collaborative, I think it's a boon. It helps bring in more innovative solutions. So many asking why space. So space has given a lot of innovative solutions, be it wipers in the car, to a lot of medical solutions that has come from space. So collaboratively done, I think it's a boon.
Thank you so much, ma'am. Considering the paucity of time, we would not be able to address all the other questions. However, we request the panelists if we may be able to send the questions to them, and then they can perhaps write back to us and answer the questions that have been posed by the audience. Also, right now, since we'll be ending this session, I would request all the panelists to provide their concluding remarks. And with that, we would conclude the panel discussion. We'll begin with Professor Reddy, sir.
Yes, I think, now participation of private industry is inevitable, because states have a constraints in fund, and now the expansion, the way space technology is expanding. I think there is an urgent need to be part of private participation. But only thing is that again, we talked about level playing field, all those things. There is a need for guarantee, confidence building measures to the private sector is the need of the hour. And of course, India, if you look at last 3-4 years, so much is happening, creating a new institutional mechanism, part of new space, Indian New Space Agency and other things. But only again, then lacuna as of now is that lack of legislation is going to be the main hurdle, according to me. So this is what my view on.
Thank you, sir. Professor Bhatt, sir, your concluding remarks.
Thank you. I should say that this is the beginning remark rather than a concluding remark. So to my understanding, I think, yes, the private players definitely need a boost for the purpose of carrying on the activities. If we have more private players, obviously the scarcity of fund problem can be actually taken care of, and more competition definitely help us for the purpose of using the outer space for the betterment of mankind. But at the same point of time, what is most important is a legislation to regulate. It should not be actually a kind of a development which is not properly being channelized. And unfortunately, I should say that in India, it's happening like that. We don't have a channelized development, especially from the legal front, if you look into it, or maybe regulators part. So we have got actually say Anthrax Corporation already operating. Now a New Space India Limited has come into existence, having the similar kind of functionalities. And there is no answer why there is a requirement of a separate one. right? So like that actually, so there are concerns. And also we have got tits and bits maybe in the remote sensing data policy. We have got SATCOM policy, which is also going to change as a SpaceCom policy now. Right? 2020 draft is basically SpaceCom. That is a kind of a change they're trying to introduce that in as well. So to my understanding, actually it is not going in a systematic way, right? Especially the regulatory framework, which is required. Of course, on the one hand, it has to promote the private activities, but at the same point of time, it should take care of all the concerns, whatever may emanate out of actually the private space activities. If such a balanced regime is there, I should say that encouraging more and more privatization in India would definitely be a boon for our economy, and also it would serve the interest of everyone. Thank you.
Thank you so much, sir. Now I request Ms. Deepana ma'am to provide her concluding remarks.
So adding a few more points to what Reddy sir and Bhatt sir mentioned, the ISRO has always worked with various companies for manufacturing mechanical and electronic components, private companies, I mean, though the design was ISRO's. So companies like L&T, Godrej were always involved for mechanical manufacturing of boosters of the rockets, and companies like Centum Electronics have been involved in the electronics sector for like decades. So because all these manufacturing are very capital intensive, that's the reason where the smaller players where the economic entry level was a barrier could not enter. But I feel like with in-space coming in and with new regulations coming in, hopefully that will allow smaller players with innovative solutions, but not so deeper pockets, to play bigger role in the entire space economy of India.
Thank you so much, ma'am, for your remarks. I would like to thank
last one remark, because we are talking about, in the global context, most of the countries actually, they, came out with a legislation policy and they opened up sectors, not only space, but in India, unfortunately, we are doing other way. We opened up sector, now we are looking for a law. This is going to be the major, issue, according to me. I'm sorry, this 1 minute, but I think, we can learn global experience, but it is not happening. Good.
Yes, sir. We would like to thank, on behalf of University Law College, all the panelists who took time off their schedules to be a part of this panel discussion. We are sure that considering their expansive knowledge on the subject, the time allotted was definitely not sufficient. So we look forward to hosting them again and perhaps have another interactive session on the topic, considering the enthusiasm of the participants and the need to know more about this subject. So we look forward to hosting you all again. And thank you so much, panelists, for spending your precious time with us today.
Okay. So thank you, sir. Thank you, Professor Reddy, sir, and Professor Bhatt and Deepana for your valuable insight into the subject. And thanks for enlightening all our participants this evening. Thank you very much.
Thank you. Thank you.
So much. Thank you for your kind invitation. It's a privilege.
Thank you. I've learned a lot, sir. And thanks for all your.
So I also thank all our professors for joining this program and all the students. And in fact, it is an initiative of our students, sir. We have best of the students and they are very dynamic in organizing all such intellectual programs. Okay. So is there any formal vote of thanks, Niharika? Or,
yes, sir. So before that, we would just like to inform the audience about the next panel discussion.
Okay.
Yes, so to all the audience members present here, we would like to inform you that on the 6th of October at 5 p.m., we will be conducting another panel discussion, and we look forward to all the participants being a part of it. The flyer for the same has been shared. Kindly go to the same. To elaborate upon it, the topic that will be discussed is reviewing the approach to countering global terrorism in India. We have esteemed panelists being a part of the panel discussion as well. First, we have Lieutenant General Dr. Prakash Menon, PVSM, AVSM, VSM, Director, Strategic Studies Program, Takshashila Institute. Then we also have Dr. Tara Karta ma'am, Distinguished Fellow, Institute of Peace and Conflict Studies, and former National Security Council Secretariat. And we have Ms. Shanti Mary D'Souza ma'am, Founder and President Mantara, and Founder Professor, Kautilya School of Public Policy, Hyderabad. So we hope to see the audience once again present for this panel discussion to view the opinions and ideas presented by the panelists. I now call upon Ms. Anaha Anlesh to render the vote of thanks.
Okay, before that, Niharika, you have to enlighten all our students to participate in this. Minimum participation should be more than 250. We have around 400 students, and only participation of 100 is not sufficient because all these programs are organized for the benefit of all. You should somehow inspire them, encourage them, okay, motivate them to take part in these things, where they will get an opportunity to hear to such an experts like Professor Reddy, Sandeep Bhatt, and Deepana and all that. Of course, many more, as you are inviting best of the people in these programs. You also should look into that. Of course, I will also make my effort, and I request all our faculty also to kindly put a word to all the concerned. Thank you.
Yes, so we'll definitely do our best.
Yeah.
I would now call upon Ms. Anaha Anlesh to render the vote of thanks.
Thank you, Niharika. I would like to take this opportunity to thank our esteemed panelists, Professor Balakrishna Reddy, Professor Sandeepa Bhatt, and Ms. Deepana Gandhi for this wonderful and insightful panel discussion. I would also like to thank our Vice Chancellor, Professor Dr. K.R. Venugopal, sir, our Principal and Chairman, Dr. Suresh V. Nadagowda, sir, Professor Dr. N. Dashrath, sir, the Dean Faculty of Law, and former Principal, Professor Dr. V. Sudesh, and all our Associate Professors, Dr. Satish Gowda, sir, Dr. Jyoti Vishwanath, ma'am, and Dr. L. Chandrakanti, ma'am, all the guest faculties and all the participants for this wonderful panel discussion and for being a part of this and making this a great success. Thank you.
Thank you. Thank you all.